Hi, this is Kathleen Bonzik. Last week, the United States Equal Employment Opportunity Commission released its enforcement statistics for fiscal year 2015. First question, what's the EEOC? The EEOC is the federal agency that enforces and interprets several of the major anti-employment discrimination statutes, including, but not limited to, Title VII of the Civil Rights Act of 1964, which bars discrimination in employment on the basis of race, color, sex, religion, national origin. The EEOC also enforces the Age Discrimination in Employment Act of 1967, and it also enforces the Equal Pay Act, as well as several other laws. Now, of all the laws that the EEOC enforces and administers, what do you think is the number one charge brought by all complaining parties? Race discrimination? Age discrimination? National origin discrimination? No. Retaliation. Not surprisingly to me, retaliation is the number one most cited charge brought by applicants and employees. Let me give you some statistics. In fiscal year 2014, the EEOC received a total of 88,778 charges under all statutes, and in the following year, which is fiscal year 2015, that number rose to 89,385 charges. So overall, what this tells us is that discrimination charges are in the increase. Retaliation charges, however, in fiscal year 2015 constituted 44.5% of all charges brought by applicants and employees. Now, this does not surprise me because in 2006, June 22nd, 2006, the United States Supreme Court, in a very rare 9-0 decision when all of the justices were unanimous on this issue, rendered its decision in the landmark Sheila White case. And in that case, the Supreme Court said that no longer does a plaintiff need to show that he or she suffered an ultimate employment action as a result of the retaliation. All that needs to be demonstrated is that the behavior suffered by the person charging the employer with retaliation must be harmful enough to dissuade a reasonable person from making or supporting a charge of discrimination. Now that is very employee-friendly and plaintiff-friendly because the plaintiff does not need to show that he or she suffered a loss of a benefit or that he or she was fired or wasn't hired or something else involving a term, condition, or privilege of employment. All that needs to be shown is that there was some conduct that was directly resulted from the retaliation that would dissuade a reasonable person as sitting in that plaintiff's shoes from making or supporting a charge of discrimination. That's the reason, in my opinion, why retaliation charges are continuing to rise in the United States. This is Kathleen Bonzik. Thank you very much for watching and listening today.